Good afternoon, everybody. I'm Samantha with the Law Offices of Samantha Wolfe, and thank you for joining us for our May monthly virtual seminar. This is a part 2 seminar. In April, we did retirement planning part 1, so today we're talking about retirement planning part 2. So thank you so much for joining us. All right, let me get up my screen here. Okay, so we're located at 20 East 6th Street in Suite 206 in Waynesboro, PA, and you can reach us at 717-655-2676. And we always like to share our mission statement. So the reason that we do these monthly virtual seminars is that we just really want to make sure we are providing some direction, some education for topics that we feel like are timely for our clients. So thank you again for joining us today. So today is Planting the Seeds, How to Grow a Successful Retirement Plan, Part 2. We're talking about the Secure Act and what we're going to call Secure Act 2.0, which we're going to talk about in a little bit. So these are just changes that we're actually seeing Congress already present. We're going to talk about how that would affect Secure and some changes that we might see and kind of the timing of when we expect that. So with that being said, let's lay some groundwork. So part 1, we talked about this, but I just want to go ahead and reconfirm or reaffirm this information. So the key changes that we had in Secure, and remember Secure was passed back in December of 2019, and it was effective beginning January 1st of 2020. So the key changes that we saw that Secure brought in was that the first distribution age is 72 rather than age 70 and a half. So if you didn't reach age 70 and a half by the end of 2019, then you aren't required to start taking required minimum distributions until you reach age 72. Secondly, there are no age caps on contributions to traditional IRAs. So pre-Secure, it was the calendar year that you turned 70 and a half, you no longer could make contributions to a traditional IRA. Thirdly, annuities are now permitted in 401k plans. And then the last key change that we saw is the postmortem RMDs over the life expectancy, the stretch that we had pre-Secure, is eliminated for almost every beneficiary unless you're one of those eligible designated beneficiaries. If you're an eligible designated beneficiary, you still get the stretch. But if you're any other beneficiary, then the money must all be out of the plan by the end of the 10th anniversary of the decedent's death. So those are our key changes. Just wanted to reiterate that. The new default rule is a 10-year rule. So we think of this as the regular people of Secure, meaning that when the Secure Act passed, they kind of found categories of individuals that they felt like should still receive the stretch, but then we have everybody else who falls into the 10-year rule. So our eligible designated beneficiaries, they're considered the superheroes in the sense that they're so important that they're going to get the stretch out treatment. So we call these our eligible designated beneficiaries. So what Secure Act did is we had the definition of a designated beneficiary. Secure then kind of said we're going to elevate a class of beneficiaries that we're going to call eligible designated beneficiaries. And that's going to be the surviving spouse. It's going to be a minor child. Now, it's important to note that once that minor child attains the age of majority, which we know based on the proposed regulations, and we're going to talk about that in a second, but the proposed regulations came out and said we know that the age of majority is age 21. So if you have a minor child, once they attain age 21, it flips to a 10-year rule. So then that beneficiary would have to have everything out of that IRA by the end of the 10th year. So, but we don't know, one of the things we don't know is how does that affect stepchildren? We know it doesn't apply to grandchildren. So we have some clients who wanted to be able to maximize that stretch, wanted to be able to take the required minimum distributions over a much longer time frame. So for their planning, they may have designated a grandchild as the beneficiary. And so in this case, that minor grandchild is not going to get the eligible designated beneficiary stretch. It does have to be a minor child. And we still don't know if that means stepchildren. We're kind of assuming it means stepchildren, but there's just not a clear definition even in the proposed regulations. The third special classification is a disabled individual. And for a while, we weren't sure, what exactly did it mean you had to be a disabled in order to meet the classifications, because it references a different Internal Revenue Code section than it does for the Social Security Administration. So it references, the Secure Act references to 72, the IRS Code Section 72, and it has a different definition. So for a while, we weren't sure what that means. The proposed regulations did provide some clarity, so we're going to go over some of that clarification for a disabled individual. Then our next category is anyone who's a chronically ill individual, then they would get the stretch out. And then lastly, individuals not more than 10 years younger than the plan participant is going to get the stretch out as well. So surviving spouse, minor child, disabled individual, a chronically ill individual, and an individual not more than 10 years younger than the participant. Those individuals are going to be the ones that get the stretch out. There are eligible designated beneficiaries. Let's talk about the proposed regulations. So Secure Act came in, was applying for anything after January 1st of 2020. And we waited and waited for these proposed regulations. So the proposed regulations are more of the explanations and kind of define certain things, gives a lot more details than what the actual statute, the secure legislation actually says. So we always look at regulations to help us navigate and figure out how this is going to apply to our clients. So originally we were expecting to receive the proposed regulations in September of 2021, but we didn't get anything back then. So that passed and we waited and waited, didn't hear anything more. And then all of a sudden we got the proposed regulations. They were issued February 23rd of 2022. So know that these are only proposed. So we're going to talk about it, but they haven't actually been finalized. So these were issued February 23rd, 2022. Comments will be received until May 25th, 2022. And then a public hearing is scheduled for June 15th of 2022. So again, these are all proposed. We don't have finalized regulations yet. So let's talk about what was the biggest thing that the proposed regulations did for us. So, and I have to give you some background as kind of how the attorneys and all the practitioners were dealing with this. So when the Secure Act came out in January, there was a lot of discussion about the 10-year rule because we already have a 5-year rule. So the 5-year rule applies if you don't have a designated beneficiary on your retirement accounts. And if you don't, there are certain circumstances in which the IRA has to be paid out within 5 years. And there's no annual distribution requirement. It's just all out by the end of year 5. So a lot of practitioners, including myself, felt like when it changed to a 10-year rule for most of the beneficiaries, it was going to be an all out at the end of year 10, and there wasn't going to be annual distributions for beneficiaries. So we had assumed that it would follow or mimic the 5-year rule. The difference would just be instead of 5, it would be 10. And it wasn't until actually last fall. So we have what's called the Estate Law Institute, and attorneys go and kind of talk about estate law, what's happening in the state administration, and it's an annual conference. And we had this year in November, it was held virtually. And there was a speaker that was from Colorado, and he was the first speaker that I had heard say, no, I think there are going to be annual distributions that are still going to have to come out. And so I was a little surprised when I heard that. And then when the proposed regulations came out, it shed some light on that. Now, it's also important to note that the assumption that practitioners made, it was not solely based on the fact that there was a 5-year rule and how that worked. It was also based on the fact that the IRS had issued a publication. It was publication 590B. And in that publication, and they actually published it, I think it was May 25th of 2021. So we're coming up on a year of that. So last May, the IRS issued a publication. They put it on their website as well as in the publication 590B that you could download in a PDF. And in that publication, they stated that there was not going to be an annual distribution amount. So there would be no annual required minimum distribution. It would just be all out by the end of year 10. So it wasn't just that as practitioners, we were saying, well, it's like the 5-year rule, so we're just going to assume that. The IRS did provide confirmation that there was going to be an all out in year 10 with no annual distributions. And then the proposed regulations came out in February, and the proposed regulations deviated from that. So what the proposed regulations are saying is that if the plan participant, so the decedent who passed away, if they died prior to the required beginning date, meaning that they hadn't reached age 72 and started taking required minimum distributions, then there is no annual RMD that has to be taken for a designated beneficiary. Now, we're assuming that this designated beneficiary is not one of those eligible designated beneficiaries who gets the stretch. So if it's just our normal designated beneficiary and the plan participant was not taking RMDs, then that designated beneficiary doesn't have an annual distribution amount. It's just all out at the end of year 10. Interestingly, the proposed regulation distinguished if the plan participant or the decedent was already receiving RMDs. If they had already started receiving RMDs, which means they would be 72 or older, then there is going to be an annual RMD requirement for the designated beneficiary. So every year, that beneficiary is going to have to withdraw a certain amount that is going to be based on the life expectancy of that beneficiary. And then in year 10, by the end of that year, the beneficiary is going to have to withdraw it all. So this is very different than what we saw in the practice and how it applied compared to the 5-year rule. Plus, the IRS had clearly said something different in May of last year. So all that to say, I know what the publication 590B said in May of 2021, and I know what the proposed regulations say. What I don't know is what's actually going to be in the final regulation. So we're going to have to wait until June to know for sure if there's going to be a required minimum distribution for all designated beneficiaries, or whether we are going to make the distinction about whether or not the plan participant was receiving RMDs. So I needed to have a whole slide devoted to this, and I needed to explain kind of why the confusion came in and why this difference is so important. And going forward, again, we just don't know how this is going to look. So if the proposed regulations, if they're finalized, then that just means going forward, any designated beneficiary that has to take an RMD will have to do that going forward. Okay, the other important thing that we saw in the proposed regulations, and I know I mentioned this in part 1 last month, and that's just the age of majority is defined. So again, in the Secure Act, it just said that a minor child could get a stretch out. And the assumption was that the age of majority would depend on what state law defined that to be. And every state can define the age of majority as something different. So when the proposed regulations came out in February, they did provide a bright line test. The IRS is saying that the age of majority is going to be when the child attains age 21. So on their 21st birthday, they would then flip to a 10-year distribution. The proposed regulations also helped provide some clarity for a disabled beneficiary. And again, I have to explain a little bit of the history so that you understand how important these definitions are. So the history is that, again, disabled beneficiary, the Secure Act references IRS, the Internal Revenue Code Section 72 as the definition. And the definition under Section 72 talks about how you have to be considered disabled for an indefinite period of time, meaning that there's no anticipated date at which you would not be considered disabled, or it references death, meaning that you would pass away because of the disability. So that's different than the Social Security Administration definition. So the Social Security Administration definition talks about how you have to be considered disabled or not have substantial gainful activity lasting for 12 months or longer. So it doesn't reference the indefinite period. So that's why practitioners, we were concerned that you might have a beneficiary that qualified for SSI or SSDI and met the definition under the Social Security Administration, but did not meet the definition of disabled under Secure. And that would mean that the beneficiary wouldn't get the stretch. And so it would have required attorneys to be very specific when they're asking questions about the beneficiary and their disability and whether or not they would be considered disabled for Secure Act purposes. When the proposed regulations were issued, one of the things that it did do that I think is very helpful is it did provide a safe harbor. So the safe harbor is just saying that if Social Security Administration has determined that an individual is disabled under their definition, then they're going to be considered disabled under the Secure Act definition. So that then does allow us as attorneys and anyone practicing in this area it's much clearer. We can guide clients better. We can help them determine whether or not a beneficiary and their supplemental needs trust will get the stretch out treatment or whether we're dealing with the 10-year rule. So the definition that was included in the Secure Act would be if the beneficiary is age 18 or older and that beneficiary is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. So that's that definition. You're going to see the last part of that talks about that could be expected to result in death or be continued for a long or indefinite duration. So know that, again, there's the safe harbor where if you have been determined disabled under the Social Security Administration, then you would meet these definitions under Secure. The second definition was talking about if a beneficiary was younger than age 18. And if so, then the substantial gainful activity isn't always helpful if they're under 18. So instead, we have the definition of the individual has a medically determinable physical or mental impairment that results in marked and severe functional limitations. And that's going to be the definition of disabled under the Secure Act. It's important to note that it does require certification of a licensed healthcare provider in order to meet this definition. And I guess maybe I overthink things because as I was reading this, one of the things that I was concerned about is it just a one-time certification or are there going to be an annual certification requirements if the beneficiary would ever be able to be rehabilitated and not meet that classification? What happens? Do you have notification requirements? Does there have to be an attorney certification for that? And again, that's still not clear under the proposed regulations. So although the proposed regulations give us more of a bright line and help us, figure all of this out as far as if a beneficiary is disabled, it's still not perfect. Okay, let's talk then about some of the other defined terms that we have. So things to know, and again, it's important to know the history and why this is important. So for a long time, attorneys had to rely on definitions that were received in a private letter ruling. So a private letter ruling would be if I had a specific client who designated, let's say, a trust as the beneficiary of their retirement account, and I was arguing that that trust should still get the stretch out. And so the IRS reviews the specific fact pattern, reviews the set of circumstances, and then makes a ruling for that taxpayer. And it's specific to that taxpayer's situation. And what happens is the IRS publishes them. And then we as attorneys, we look at that and we say, okay, well, as it applies to our clients, if we had either these exact set of circumstances or similar, what is the IRS telling us? So a lot of the defined terms that we've used in practice for years weren't actually defined in the legislation. They were gotten from private letter rulings from the IRS. So the proposed regulations did provide black and white definitions for what a see-through trust is, what a conduit trust is, and what an accumulation trust is. These definitions are all very important when we're trying to determine designated beneficiaries of the decedent's IRA. Because remember, if it's not a designated beneficiary, then it may be that it's subject to a 5-year rule. It may mean more tax. So the definitions tell us that if your trust meets these definitions, then it's considered a designated beneficiary. Now you have to take that one step farther and you have to say, if it meets the definition of a see-through trust and can be a designated beneficiary, are all the beneficiaries of the trust those eligible designated beneficiaries? And if the answer to that second question is yes, then you can get the stretch out for the trust. If the answer to that is no, that not all of the beneficiaries meet the eligible designated beneficiaries, meaning that it's not a surviving spouse, it's not a minor child, it's not a disabled individual, it's not a chronically ill individual, and it's not an individual who's less than 10 years younger than the plan participant, then if there's just one beneficiary there, then it's going to negate that stretch out and it's going to be subject to a 10-year rule. But at least it's the 10-year rule and not the 5-year rule. So a see-through trust is going to has to meet 4 requirements. So it has to be valid under state law. It has to be irrevocable, or it will be irrevocable at the time that the employee dies or the decedent passes away. It converts to irrevocable. Number 3, the beneficiaries of the trust who would be receiving distributions under the trust terms they have to be considered individuals, meaning that you still can't name, for example, a charity, your estate, your creditors, because that's not considered an individual and it's not going to meet the definition. And then number 4, the specified documentation has to be given to the plan administrator or the custodian by the certain date that's in the legislation. Now, just as kind of a rule of thumb, in our office, we typically, when we do designated beneficiary forms, we typically send a copy of the trust if we're designating the beneficiary so that they already have it on record. But assuming that you don't already give the company a copy of the trust, then you want to make sure they have it by the date. And we're going to go over those important dates, meaning that in the year after the decedent died, the trust has to be provided to the plan administrator by a certain date. A conduit trust is a see-through trust, so it meets all those 4 requirements that we just went over. It's a see-through trust, but it means that the trustee has to pay out any distributions received from the retirement account automatically to the beneficiary. So what that means is that the trustee draws it down from the retirement account, it comes into the trust, and then the trustee immediately distributes it out to the beneficiary. So it's really kind of just passing it through and out to the beneficiary. That's a conduit trust, and we got that clearly defined in the proposed regulations for SECURE. And then an accumulation trust is any other trust that is not a conduit trust. So what that means is it's any trust where when the trustee draws down from the retirement, instead of paying it immediately out, the trust may say the trustee has the discretion to distribute it out, or there's a certain amount that comes out every year. So again, it's just one where it doesn't require the distributions or the withdrawals from the retirement to immediately pay out to the beneficiary. That's going to be an accumulation trust. Okay, so let's talk then about beneficiary tiers. So I know that all of these terms seem really confusing, but just know from an attorney standpoint, these definitions are so helpful, because what would happen is if my parents had created a trust where I had my sisters and I as the beneficiary, and then they designated that trust as the beneficiary of retirement, there were all kinds of questions about whose life expectancy or who was the beneficiary of the trust. So if my parents said, goes equally to the 4 daughters. If they don't survive, then it goes to any children they have. And then if there are no children, then it goes to a charity. The question becomes, does that automatically make it so that it doesn't qualify as a designated beneficiary because the 3rd beneficiary was a charity, and charities are going to make it so that you don't meet the 10-year rule and you don't meet the stretch out rule. It's not considered a designated beneficiary. So as attorneys, we for years have struggled with at what point can you stop counting the beneficiary? How far down do you have to go when you're trying to figure out who is the designated beneficiary of this retirement account? So the proposed regulations divided it into 3 tiers. So there's tier 1. So that's those beneficiaries who would receive distributions from the trust upon the death of a plan participant without having to wait for somebody to die. So in the example I just gave you, if mom and dad have a trust where the 4 of us are beneficiaries, all 4 of us are considered tier 1 beneficiaries because we're not waiting for someone else to die in order for us to receive those funds. Tier 2 would be the beneficiaries who could only receive something if a tier 1 beneficiary would pass away. Best example would be grandkids for my mom and dad. So if they said that, it goes equally to the 4 daughters, and if one of the daughters passes away, then that share goes on to that daughter's children or their grandkids. Then the grandkids are going to be considered tier 2 beneficiaries. They're not getting anything until a tier 1 beneficiary, one of the daughters, would pass away. So grandchildren would be considered a tier 2 beneficiary. A tier 3 would be anybody, any individual or any other organization who receives a benefit after the death of the 2nd tier beneficiary. So in the example, if mom and dad have the 4 daughters, then the grandkids, if the daughters would pass away, and then it's charity, the charity would be a tier 3 beneficiary of the trust. And so the question becomes, who do we look at when we're trying to determine, is it a designated beneficiary? Meaning, can we at least get the 10-year rule? And if we're under the 10-year rule and we do have to take RMDs, if the proposed regulations are going to require that, then how do we determine which life expectancy we have to use? So these were all questions that we struggled with. And the good news is that the proposed regulations give us some very clear definitions. So tier 1 beneficiaries, in the example, that would be my sisters and I, they always count, meaning that if you want to know if this trust qualifies as a designated beneficiary. You have to identify all the tier 1 beneficiaries, make sure they're all individuals because they're going to count. If you have just one tier 1 beneficiary, so if it would be that my mom and dad said we're going to name all 4 daughters and then we're going to have 10% go to charity, because the charity was a tier 1 beneficiary, that's going to be problematic. So again, you have to identify who all is a tier 1, and they're always going to have to be accounted for when you're determining whether or not it counts as a designated beneficiary. Second thing to know is that tier beneficiaries are always disregarded. So in the first example where it's paid to the 4 daughters, then if they die, it goes to grandkids. And then if the grandkids pass away, then it goes to charity. Technically, the charity is the tier 3 beneficiary. So what that tells us is that just because you have a charity as a beneficiary of a trust doesn't automatically make it so that all of the retirement has to come out within 5 years. Because again, tier 3 beneficiaries are always disregarded when we're determining whether or not this trust will at least get the 10-year distribution rule. The third thing to know is that you have to identify whether or not the trust is a conduit or an accumulation trust. And that's because if it's a conduit trust, then tier 2 beneficiaries are disregarded. Meaning that in the example where my sisters and I are beneficiaries, if my parents have the trust provisions say the trustee pulls it from the IRA and then immediately distributes any distributions out to the 4 of us, then it means that the grandkids aren't going to count as beneficiaries of the retirement account. So we don't have to look at them when we're trying to decide what the payout of that retirement account is. But you have to know if it's an accumulation trust, meaning that if mom and dad have the trust provisions say that the trustee can draw it down and then has the discretion to distribute it to my sisters and I, then technically that's an accumulation trust because the distributions from the retirement account are not automatically paying out to the 4 of us. So that means that tier 2 beneficiaries count unless they're disregarded under another rule. Now, the reason that I put this last bullet point on the same slide is that one of the reasons that beneficiaries can be disregarded under another rule is if the beneficiary is going to receive an outright distribution by age 31, then you don't have to count those beneficiaries. Interestingly, I'm not sure why the IRS picked the age 31, but that's the age they picked. I feel like it would have made more sense if they picked age 30 or 35, but they picked age 31. So what that means from an attorney standpoint is when we're drafting these trusts, there might be some benefit if we're going to be naming certain beneficiaries. So for example, if let's say mom and dad named multiple grandkids, and let's say we had some grandkids that had special needs or we had other beneficiaries who were chronically disabled, that means that they would be those superhero beneficiaries, those eligible designated beneficiaries. So they would be able to stretch the distributions out over their life. So let's say that mom and dad did a trust like that. And so again, it's important to know that all the beneficiaries have to be one of those eligible designated beneficiaries in order for you to get the stretch for the entire trust. Otherwise, it doesn't work. And so what this is saying is if mom and dad would say they wanted that, one of the drafting techniques we can use is we can say, okay, if we're concerned about one of those contingent or those tier 2 beneficiaries messing up the stretch for those eligible designated beneficiaries, then we can make it so that at age 31, it's going to pay out to maybe those tier 2 beneficiaries. So it's just more of a drafting safe harbor for attorneys to make sure that if you do have beneficiaries that you want to name that either aren't eligible designated beneficiaries or aren't designated beneficiaries, it doesn't completely jeopardize the entire trust. Isn't this fun? So then we have a framework to calculate distributions for a trust. So first question is it a valid see-through trust? You have to meet those 4 requirements: valid under state law, it's irrevocable at the time of the decedent's death, it has to have all individuals as the beneficiary, and you have to get the plan administrator a copy of the trust. If it meets all 4 of those, then we have a valid see-through trust. The next question is we have to determine, is it a conduit or is it an accumulation? And that just is whether or not the trustee takes any distributions from the IRA and pays it out. Does the language state that? And if so, then you're a conduit trust. If not, you're an accumulation. And then you have to identify the tiers of beneficiaries because, again, tier 1 always counts. Tier 2 only matters if it's an accumulation trust, and tier 3 never matter for any trust. So let's talk about important dates. So there are certain dates that you have to know for IRAs and the distributions when you are a beneficiary. So the first is that September 30th is the deadline for finalizing beneficiaries. And that date is going to come up in one of the later slides. So know that September 30th in the year after the decedent's death, that's when we're going to cut off, and that's when we're going to say, who are these beneficiaries? That's when we have to know for certain that those are all designated beneficiaries. The important thing to know is that if you have a beneficiary of a retirement account who's not a designated beneficiary and you're able to pay them out prior to the September 30th date, then you've met the cutoff. And as long as all the beneficiaries as of September 30th are designated beneficiaries, then you don't have to worry about it jeopardizing either the stretch or the 10-year rule. Second date is October 31st. So that's the date that you have to have that trust documentation to the IRA plan administrator or the custodian. So that's to meet one of those requirements to be a see-through trust. And then December 31st is the deadline that applies for separate accounts. If you would want to make separate accounts for the multiple beneficiaries, you have to do that by September 30th. The proposed regulations, not only did they provide definitions, they kind of classified beneficiaries, tier 1, tier 2, tier 3, which is really helpful. The other thing they did is they outlined situations in which the beneficiary can be disregarded. So there are two classifications. So there are certain situations that says that if events occur prior to the September 30th cutoff of determining the designated beneficiaries, if certain things are done by then they're going to be disregarded. And then there's another class that says, we don't care when it happens. It can happen after September 30th, and they're still going to be disregarded. So let's go over the first set. So situations where a beneficiary can be disregarded would be where the beneficiary predeceases the plan participant. So if that happens prior to September 30th, then you can disregard that beneficiary. If the beneficiary who is treated as having predeceased the plan participant by reason of a simultaneous death provision under applicable state law or via qualified disclaimer is disregarded, as long as that occurs prior to September 30th. If the beneficiary who receives the entire benefit that the beneficiary is entitled to, if they receive that by September 30th, you can disregard them. Or lastly, if there's a power of appointment. So a power of appointment would be if the best example would be, I don't have children. So if mom and dad said, if something happens to Sam, we're going to give her the power to appoint her 25% to any of the nieces or any of her nieces or nephews, which would be mom and dad's grandchildren, that she would want. So what they're doing is they're saying, I can appoint my share to any of their grandchildren. So if they would give me that, that would technically be a power of appointment, and it would be limited in nature. And as long as I exercise that by September 30th, then anyone else can be disregarded because I've actually exercised it by that date, and we know clearly who those beneficiaries are. Situations where a beneficiary can be disregarded, even if that interest is not eliminated prior to the September 30th date, would be accumulation trust beneficiaries when entitlement of such beneficiary is conditioned upon the death of any and all tier 1 beneficiaries. So remember, that's tier 1 is who, as soon as the decedent passes away, has the right to receive distributions from the trust. So we're talking about any beneficiaries when entitlement of such is conditioned upon the death of any tier 1, and at least one tier 2 beneficiary has to pass away. So we can disregard that. So again, that's a tier 3 beneficiary. We talked about that. It's a very wordy way that the proposed regulations state that. So it doesn't matter if that occurs after September 30th, we can disregard. The thing to know about proposals dealing with modification, reformation, so meaning amendments to trusts or modifications of trust that are made. So the proposed regulations do provide that if the amendment, modification, or the reformation of the trust is made prior to the September 30th date of the calendar year that's following the calendar year of the plan participant's date of death, then you can determine whether or not those are considered designated beneficiaries. So again, it's the September 30th deadline. If a trust beneficiary is added after September 30th, then the addition of the new beneficiary will affect the life expectancy calculation. If a beneficiary is added in a calendar year in which a full distribution is not required, and after that addition, such beneficiary, the distribution would have been required to them, then the full distribution shall not be required until the end of the calendar year following the calendar year in which the beneficiary was added. So that just gives that beneficiary a little bit more time to take that distribution if they would need it. Okay, so situations where a beneficiary can be disregarded even if it's not eliminated prior to September 30th would be remainder beneficiaries of conduit trusts are still disregarded. So remember, that's where we're talking about the tier 1, tier 2, tier 3. So if we have an accumulation trust, it's all about what tier you're on. Remainder beneficiaries of a conduit trust are still disregarded even if it's after September 30th. A beneficiary of a see-through trust may be disregarded if the entitlement is conditioned upon the death of an individual who has not reached the age of 21. If the terms of the trust require full distribution within 10 years, that's that age 31 that we talked about. Okay. I know that was tons of fun talking about all those definitions, but I thought it might be helpful for those of you who kind of wanted to know what attorneys have to be factoring in when we're doing retirement planning now. I think, though, the rest of the presentation is a little more fun, if we can say that this type of presentation is fun, and that's talking about Secure Act 2.0. So let's talk about that because we're going to hear about it in the news. We're going to see new proposals coming out during this latter part of the year. So Secure Act 2.1, this was in March of 2022. There was a vote taken in the House of Representatives. It was 414 to 5 in the House of Representatives. It approved a second bill, Securing a Strong Retirement Act of 2022. It's nicknamed Secure 2.0. It gets that nickname because it was introduced by two representatives, Richard Neal, a Democrat in Massachusetts, and Kevin Brady, a Republican in Texas. These are the same lawmakers who spearheaded the original passage of the Secure Act. And this is so important because the fact that it's these original gentlemen who spearheaded it, and the fact that it was Secure was passed so overwhelmingly when it was passed. This Secure 2.0 is expected to pass sometime in the back half of 2022, and commentators are basing that on the bipartisan support and the unanimous backing of the original Secure Act. So that's why I wanted to take the last couple of minutes and talk about this Secure Act 2.1. So I always have to make sure everybody knows these are not actually laws that are in effect now. These are just proposals that have come out in legislation that we've seen, and this one was in the House of Representatives. So let's talk about what this one does. So change number 1 would be it raises the age for RMDs from age 72, that Secure Act increased. It's going to increase it to age 75. So that is going to allow more time for money to grow tax-free in somebody's retirement prior to having to start taking the RMDs. But know that that means the RMDs are probably going to be higher every year that you have to take them because there's less time to pull it out. So RMDs would initially increase to age 73 starting January 1st, 2023, age 74, January 1st, 2030, and then age 75 on January 1st, 2033. So again, it's a 10-year period before you get to the full age of 75. Change number 2 deals with the excise tax. So the excise tax is a tax that the IRS places on you if you're not taking the required RMDs. So currently the excise tax is 50% if you fail to take your RMD when you're supposed to. Secure 2.0 would reduce the excise tax to 25%. And if you correct that mistake in a timely manner, they'd have a cutoff that you have to correct it. And if you do it, then automatically the penalty is reduced to 10%. Now, it's important to know that there is a waiver. You can apply to get this excise tax even now waived for certain reasons, meaning that you didn't know, it was a mistake. There are all kinds of reasons that you can apply to get that excise tax waived. What Secure 2.0 is saying is that you don't even have to file the waivers. If you correct it within a certain amount of time, then it's going to reduce the penalty automatically without you having to actually take any action to get the excise tax waived. Change number 3 is an auto enrollment and retirement savings plan. retirement savings plans. So this is more impactful for employers. So it's going to require employers to automatically enroll eligible workers into the firm's 401k, 403b plan at a rate of 3% of the salary. So right now, for example, businesses have the option to do retirement plans. So what this would be saying is that businesses no longer have the option. They have to require, or they have to offer, I should say, employees the right to contribute 3%. What that means is that employees can opt out of it if they want to, or opt to save less, or they can opt for more as long as it's below the annual contribution limits. Enrolled workers' contribution rates would automatically increase each year by 1% until the contribution reaches 10%. And businesses with fewer than 10 employees, businesses which owned fewer than 3 years ago, and retirement plans for churches and government agencies would be exempt, but otherwise you would have to provide a retirement saving plan for businesses. Plans in place prior to enactment would be exempt. So this change number 3 is really putting the burden on employers to have a retirement savings plan if you don't meet one of those exceptions. Meaning if you're a small business with less than 10, you don't have to do it. If you're a church or a government, you don't have to do it. And if you had your business owned less than 3 years. Now, as soon as you hit that 4-year mark, though, you're going to be required to set up a retirement savings plan. So again, not so impactful necessarily for you. It's more impactful, I think, for employers and knowing that you would have this right if this passes. Change number 4 would be incentives for contributions. So currently, as employers, we're prohibited from providing financial incentive to encourage workers to contribute to a 401k, but Secure 2.0 would allow us to give gift cards to try to incentivize our employees to want to make contributions to a retirement plan. So that being said, if you have a retirement plan in place and maybe your employees aren't contributing to that, you could give them gift cards to like local restaurants to try to get them to make contributions if you would want to do that after this passes. Change number 5 would be larger catch-up contributions would be permitted. So workers who are at least 50 years old can make catch-up contributions to their retirement accounts. So for 2022, workers can contribute an extra $6,500 after hitting $20,500 limit for 401ks, for 403bs, and add $3,000 more to the $14,000 cap in 2022. Secured 2.0 would allow workers who are age 62, 63, or 64 can make contributions of $10,000 to a 401k and a 403b, or an additional $5,000 to a simple. And then lastly, it would allow catch-up contributions to be adjusted for inflation. So the last time that we had an increase, it was in 2006. That was the annual increase that was limited to $1,000. So in this case, the catch-up would be adjusted for inflation annually. Change number 6 is a better savers credit. So middle and lower income people who add money to their IRAs, 401ks, 403bs, SEP accounts, they can get a savers credit. So right now, maximum saver credit of $2,000 for joint filers and then $1,000 for others. That's currently capped at 50%, 20%, or 10% of contributions, depending on what your adjusted gross income is. Secure 2.0 would have one credit, and it's just going to be a flat 50% credit rather than those 3 different percentages. However, the eligibility would start at a lower adjusted gross income than the currently. So right now you have 3 different levels. It all depends on where your adjusted gross income is. Secure 2.0 would say, we're going to say it's 50% for everybody, but that 50% is only going to apply to people below a certain adjusted gross income. The credit would fully phase out at AGIs of over the 24,000 for single filers, 36,000 for head of household filers, and 48,000 for joint filers. Change number 7 would be an employer can match funds for student loan payments. So employers would be permitted to make matching contributions to a worker's retirement account based on their loan repayment. So a lot of times when you have younger employees, they may choose not to make contributions to their retirement because they want more in their pocket to pay student loans back. And so what this is saying is even though they aren't making a contribution to their retirement account, the employer could still make a contribution if that employee is making student loan repayments, and it would be matching that contribution. Difference is you're paying it into a retirement account. This is modeled after the 2018 ruling from the IRS, where an employer match took place regardless of whether the employee also paid in. Change number 8 would be finding old 401ks. Interestingly, I just did this presentation for the Pennsylvania Bar Institute for other attorneys, and I had a co-presenter on, and we were talking about this topic, and I didn't realize this was a problem because most of the time when I have clients come in, they know about their 401k, the executor knows about the 401k, but in certain situations, it might be difficult for employers to find former workers who may have changed their name or address, and they need to pay out benefits. And so Secure 2.0 would require the Department of Labor to create a national online lost and found database for retirement plans. So I think it would operate very similar to Pennsylvania's unclaimed property database. Right now, you can get on the website for Pennsylvania, and you can enter in a decedent's name, and you can find out if they had unclaimed property in Pennsylvania. So it sounds like it's going to be something similar. It's going to be the Department of Labor's job to create that database. Change number 9 deals with QCD enhancements, and I wanted to make sure to mention this because I know I have some people who are on here who ask about distributions from retirement directly to a charity. And so know that this change deals with that. So people age 70 and a half or older can transfer up to $100,000 tax-free each year from a traditional IRA directly to a charity. It's considered a qualified charitable distribution. It never gets added into your adjusted gross income. And notice that that's age 70 and a half, even after Secure. So even though you don't have to take a required minimum distribution because you're not 72, you could still, beginning at age 70 and a half, do this qualified charitable distribution. So it counts as part of the RMD, but it's not considered taxable to you, and it's not added to your adjusted gross income. So Secure 2.0 would annually index that 100,000 for inflation, and then additionally would allow for a one-time QCD transfer up to 50,000 through a charitable gift annuity or through a charitable remainder trust. So I wanted to make sure to highlight that because I know it's come up a couple of times to some of the clients who are so gracious and get on and support us and listen to me drone on all the time about all of these fun topics. So just know that there are some changes to the QCD enhancements that would come on, that would change and allow us more flexibility under Secure 2.0. Change number 10 would allow more Roth contributions. So currently, simple and SEP IRAs are not allowed to accept Roth contributions from employers. Other retirement plans like 401ks, 403bs, they can accept Roth contributions. So Secure 2.0 would allow simple and SEP IRAs to accept Roth contributions from employees. It would also require catch-up contributions to 401ks and other qualified workplace retirement plans to be subject to the Roth treatment. The extra $6,500 contributed by workers age 50 or older would automatically go into a Roth 401k and come from post-tax salary rather than pre-tax wages. It would allow 401k and other plans to give participants the option of having any employer matching contribution put into the Roth 401k accounts. So currently, the matching contributions must be on a pre-tax basis. So this is an important proposal because this component of Secure 2.0 would be what generates revenue to offset the cost of other provisions of Secure 2.0. So it's going to raise money when contributions are made. Because remember, Roth are when it's after tax dollars, you've already paid the tax and it's going in. So this proposal, this particular component is designed to be generating revenue of Secure 2.0. Change number 11 is part-time workers' retirement eligibility. So currently, companies that offer a 401k are now required to allow employees to work at least 500 hours a year for 3 consecutive years in order to be able to contribute to a retirement account. Secure 2.0 would reduce the 3-year rule to a 2-year rule, so those part-time employees could start contributing earlier. Change number 12, 403B plan investment options. So generally plans only invest in annuity contracts and mutual funds, which does prevent those participants from investing in collective investment trusts. So Secure 2.0 would allow 403B custodial accounts to invest in collective investment trusts as long as they meet certain criteria. And that would be subject to the ERISA regulations. Change number 13 deals with relief for domestic abuse victims. So early withdrawals under Secure 2.0 would waive the 10% penalty for early withdrawals up to the lesser of $10,000 or 50% of the account for people who self-certify that they have experienced domestic abuse. So important thing to know is that this is a self-certification. Second thing is it's the lesser of the 10,000 or 50% of the account that they could withdraw without having to pay the penalty. So the penalty is when you withdraw it earlier than the minimum age of 59 and a half. So if you're taking a withdrawal from your retirement and you're older than 59 and a half, you don't have to worry about the 10% penalty. But if you're younger than 59 and a half and you're taking distributions from a retirement, there's a 10% penalty. So what this does is it gives a carve out exception to those individuals who would be victims of domestic abuse. Regular income tax on those distributions could be paid over a 3-year period, because you have to realize that when you pull down from a retirement account, unless it's a Roth, if it's a traditional, you're going to have to pay income tax and claim that distribution in your income tax. So this not only would waive the penalty, but it would also allow you to pay that tax over a 3-year period. Change number 14 is our small business tax credit. So employers with up to 50 workers would be able to offset some startup costs in order to get their retirement plan going for their business. So small businesses would be able to claim a tax credit for joining a multi-employer plan, no matter how long the plan has existed, for 3 years. So currently you get the credit only if the plan has been around for less than 3 years. Small business would also be eligible for a tax credit for defined contribution plans if they allow spouses of those serving in the military to participate in the plan within 2 months of joining the company. So again, it's just offering some incentives for maybe some employers to offer more options for their employees to be making contributions. So I will say that the last few changes don't necessarily affect the decedent or the plan participant. It's more of providing carve outs for when these funds can be used and how it affects the employer. But I wanted to go over, and these are the highlights. So I just picked 14 changes, kind of highlighted what I thought was important after I was reading the legislation in Secure 2.0. So know that, again, this is just proposed at this point. Again, if we go back to our slide here, it's because I want everyone to know the numbers. So March of 2022, it did pass the House, and it was an overwhelming passage, so 414 to 5 votes. And so you have to keep track of this. I know in our office, we're going to be keeping track of it just to see how this plays out. Normally, when things like this then go to the Senate, there's some back and forth about different provisions. They might tweak them, they might add stuff, they might take it away. But just know that this is in Congress right now. They are working on it. And it does seem likely that this would pass in the back half of 2022. That's based solely on the fact that it's the original spearheaders of Secure, and that Secure was passed so overwhelmingly when it was passed back in 2019. So that being said, I think I covered all of the material that I wanted to cover today as deals with retirement. So those of you who are receiving our newsletters, you probably have already noted this. So for the summer, we're taking off the summer as far as traditional virtual seminars. So I will admit that I want to regroup and kind of do some different topics. So we've been doing a virtual monthly seminar since we started in July of 2020. Every month we've been doing a seminar. And so for the summer, we thought it might be fun to do something a little bit different. So these are my two nieces. Lily's on the left, Maya's on the right in the picture. So we're going to do centerpieces with the nieces. We're going to do a part 1, part 2, part 3. And so what we're going to do is they won't be live. We're going to pre-tape them, and we're just uploading them to our YouTube account on those dates. Now know that I'm sure there are going to be some fun questions, just like there were in the newsletter, that we'll chat about. But I also thought it might be nice to go back and kind of ask some basic questions and be able to answer them in a more straightforward, short answer. So we're also going to do some fun things, like we will do a virtual tour of the new office upstairs. So for those of you who haven't been here at our office, you can kind of join in on what we've been up to as far as decorating and getting everything organized. So we're excited about it. That being said, we will come back in September with our monthly virtual seminars. And especially for those of you who have been on our seminars, I welcome your feedback, because I'm always trying to think of new information that I can make sure to be getting to you folks. So if there's something in particular that you want me to cover maybe more thoroughly, or a topic that I haven't covered, feel free to email Amy and Jess at my office, and we can certainly add that to our lineup in the fall. So that being said, I just want to thank everybody for being on the call today. I'm Samantha with the Law Offices of Samantha Wolfe. We do consultations, so you can call us at 717-655-2676. I'm going to stop the recording and I'm going to take some questions now. Thank you, everybody.